With respect to the state's case, at this point in time, the defense would move for judgment of acquittal. The state's indicted Mrs. Adelson on 3 counts: first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. All 3 charges, obviously, of the indictment require that the state present evidence that Mrs. Adelson intended for Mr. Markell to be killed. However, as this court is aware, judgment of acquittal should rarely be granted on the issue of intent. However, the remaining issues are different. Specifically, whether the evidence lends itself to a finding that Donna Adelson was a principal to first-degree murder, whether she conspired for Mr. Markell to be killed, or she solicited another to kill Markell. To go through this briefly, Your Honor, to prove the count 1, the state has to establish, obviously in the light most favorable to the state, the evidence would have to support a finding that Mr. Markell is dead. The death was caused by the criminal act of Mrs. Adelson, and there was a premeditated killing of Daniel Markell. Since there's no evidence that Donna Adelson herself committed the crime, you have to look at the principal instruction. Principal instruction requires that, in the light most favorable to the state at this stage of the trial, that there is competent evidence that Donna Adelson helped somebody else or other persons commit the crime. Specifically that she intended the crime to occur, and I think we go back to the initial statement I made about intent, but also that she did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. And for this, I think it's important that we look at how that is defined. And the most recent case on the issue where it was discussed at length is Denise Williams. And the Williams case, the first DCA, focused on what was done the day of. So in this case, it would be July 18th of 2014. And the site for Mr. Williams' case is 314 Southern 3rd, 775. It's the first DCA from 21. It's our position, Your Honor, that there's no evidence that Donna Adelson did some act or said something that was intended to and that can incite, cause, encourage, assist, advise, or advise the other person or persons to commit the crime. And as Williams indicated, you have to focus on what Mrs. Adelson did on July 18th of 2014. Williams' decision says proof of conspiracy alone is not enough. And so, in the light most favorable to the state, let's go through briefly what the evidence reflects. Daniel Markell was killed by Sigfredo Garcia, who was driven to and from the scene by Luis Rivera on July 18th of 2014. Both of them were solicited by Catherine McDaniel to drive from South Florida to Tallahassee. Luis Rivera testified that they were hired by the Wennndy lady to get her kids back. Luis Rivera testified that he saw that Sigfredo Garcia had a picture of Markell with some writing which he believed to be an address. They made 2 trips to Tallahassee. During both of those trips, according to Mr. LaCoste, Wennndy Adelson acted extremely anxious and exhibited odd behavior. At the time of both of those trips, Mr. LaCoste was scheduled to be heading out of town, and he drove a vehicle that looked similar to the ones rented by the shooter. There's no evidence that my client ever spoke with Catherine McDaniel, Sigfredo Garcia, or Luis Rivera.
Your client did speak, however, with Charles Adelson in the chain of communications. I believe the state's wording was the train cars.
Yes, Your Honor. I'm going to get to that.
Go ahead.
Thank you. The evidence, the undisputed evidence, is that Charlie Adelson kept stacks of stapled cash in his house. There is no evidence that Donna Adelson did the same. The evidence also reflects that Charlie Adelson had a safe the size of a refrigerator. There's no evidence that Donna Adelson had a similarly large safe. Before Mr. Markell was murdered, Wennndy Adelson told Jeff LaCoste that the only way she could leave Tallahassee is if something happened to Mr. Markell. There is no evidence that Donna Adelson was aware of this statement made by Wennndy Adelson. And there is no evidence that she also agreed that there was no way that Wennndy Adelson could leave Tallahassee unless something happened to Dan Markell. before Mr. Markel was murdered, Wennndy Adelson told Mr. Lacoste that Charlie looked into hiring a hitman in the summer of 2013 after relocation was denied. There is no statement in evidence whatsoever that Donna Adelson was either aware of them, or said or did anything to encourage that or incite that. There's also no evidence that had been admitted that Donna Adelson was aware of the claim, that Charlie Adelson actually looked into that. Additionally, before Mr. Markel was murdered, whenever Charlie was on the phone with his mother, he would walk out of the house to speak with his mother on the phone, and Catherine McDonald was there. After Mr. Markel was murdered, Catherine McDonald went to Charlie's house. Charlie, according to the evidence, the light most favorable to the state, Charlie told her that his parents had just left. I rewatched her testimony over the weekend. During her testimony, she did not say that Charlie said anything at that point about his parents leaving money at the house. She testified that she woke up the next morning and Charlie said he had put the money in the trunk. She then left and tried to locate Sigfredo Garcia. She testified that when she got the money back later that day or the following day, the money was stapled together. Her testimony was pretty clear. She said a couple of days later, I'm pretty sure I contacted him and asked him why the money was left. She did not say that she did. After Mr. Markel was murdered, Donna Adelson followed her daughter's instructions and used the last name Adelson for her grandchildren. After Mr. Markel was murdered, Donna Adelson conveyed the message from their family attorney, Weinstein, to Ralph Adelson to not talk to the cops. After Mr. Markel was murdered, Donna Adelson wrote checks from Charlie Adelson's business account to Catherine McDonald at Charlie's instruction. The evidence that has been admitted reflects that that business belonged to Charlie from 2012 to 2020. As this court knows, being a manager of an LLC is not the same as being an owner. After Mr. Markel was murdered and the bump happened, Donna Adelson begged the undercover to go to the cops and tell them what he knew. After Mr. Markel was murdered, Charlie kept up the lie that he told Donna Adelson when discussing the arrest of Sigfredo Garcia and Luis Rivera. Now, the only way, it is our position, the only way that the state overcomes counts 1 and 3 is by improper stacking of influences. So they have evidence that Donna Adelson allegedly hated Mr. Markel. The evidence is that Donna Adelson didn't like how Dan Markel treated Wennndy. The evidence reflects that from 2012 to 2013, according to the emails from Donna Adelson, a non-negotiable was relocation. However, after July 31st of 2013, there has been no evidence admitted in this trial that Donna Adelson said or did anything to convey the message that she would do anything for Wennndy and the children to move to South Florida. There's no mention.
As to the argument about inferences, however, inferences plus a confession, and you're saying the state has not been converted?
Judge, I'm getting to that.
Please do.
There's no evidence that she solicited anyone to murder Markel aside from these assumptions. The emails, the text messages, the testimony, no one has said that my client solicited anybody to commit murder. The evidence reflects that Donna Adelson vented to Charlie Adelson about how Markel treated Wennndy, but as I said, there's no evidence aside from assumption that she went a step further. The state has submitted the July 17th, 2013 email to her parents' shared account, and one of her parents responded well. The evidence also reflects that had it been Donna Adelson that responded, all the other email correspondence that's been admitted reflects that she would have said something much longer. But even if she did know it, the motion itself, and I would ask the court to take a look at the prayer for relief in that grandmother motion, it was not to prevent Donna Adelson from spending time with the boys. It was to spend, or unsupervised, it was to prevent her from spending time with the boys in contravention of the right of first refusal, not to prohibit any unsupervised contact. So even if the court were to find that in the light most favorable to the state that my client was aware that the grandmother motion was filed, the relief that the state believes was sought is not what was sought in the motion. As to the alleged confession, Your Honor, what the confession, as I heard it, was that she wrote the checks. She paid the money after.
I think we'll get the court reporter to read it if need be, but go ahead, please.
What she did after the murder is not evidence of her intent prior to the murder. And that's what Williams talks about. What evidence is there in the light most favorable to the state that prior to the murder, Mrs. Adelson did something? I think that if we were before the court on a different charge, and the statute of limitations had not expired on it, that the situation might be different. But we're here for principal to first degree murder, conspiracy, and solicitation. Venting about how somebody is treating their daughter is not the same as asking somebody to have them killed. The evidence reflects that, I know that the state's argument or belief is that the birthday gift is a murder. The birthday gift, the evidence reflects, was the party and the catering. You have to make an inference, on top of another inference, that the birthday gift was murder. So focusing on what evidence exists as to my client's statements and actions prior to the murder actually happened. According to Williams, judgment of acquittal is appropriate on count one.
Concerning Williams specifically, was there evidence of consciousness of guilt admitted against the defendant in the same way it's been in this trial?
In Williams?
Yes.
I don't believe so.
So in addition to any circumstantial evidence, any inference, we also have in this record the defendant allegedly making a confession, suborning perjury, and attempting to flee. As to those pieces of evidence linking up with the others, what is your argument?
Well, Your Honor, I think Williams speaks to the fact that there's even more evidence. In Williams, you had the co-conspirator testify directly that Miss Williams was involved in the planning, but she wasn't involved in the execution. All of those, the after the fact things, yes, it might be relevant to consciousness of guilt. However, it doesn't overcome the absence of evidence as to what Donna Adelson did on July 18th of 2014. That's what Williams speaks to.
And you are disputing that she dropped off any money to Charles Adelson on that date as payment to the trigger gun.
What I'm saying is that there's no evidence that she knew on July 18th. In the light most favorable to the state, obviously I disagree ultimately that that's what happened, but in the light most favorable to the state, which is the standard that we're applying here today, there has to be that next step, that she knew what it was for. And there's no evidence that she did. As a result, Your Honor, we're asking the court grant judgment of acquittal on counts 1 and count 3.
Response from the state.
In considering this JOA argument as to whether there is sufficient evidence for this defendant to be a principal to the charges, the state first wants to point out the emails in this case that detail the defendant's hate for Dan Markell and her motive. If he's out of the picture, then Wennndy and the grandsons can come to live in Miami where she is, and she was the person who benefited most from this crime by them being able to do that. We also heard from Luis Rivera. He said that he and Garcia followed Dan Markell's car from his home to the daycare, to the gym the day of the murder, and had surveilled Dan Markell's comings and goings from the park outside of Trescott Drive in the month before and the weekend of the murder. We also saw in the defendant's planner where in 2014 she had the year, make, model of Dan Markel's car as well as his license plate. We also heard from Catherine McBanois. She said that Charles Adelson said that his parents had just been at his house the night of the murder when she arrived, and then also told her his mom had washed the money. This was the same money that was provided to the killers and that McBanois found was wet. That testimony was corroborated by phone evidence showing that the defendant stopped at Charlie Adelson's house the night of the murder. We saw the text message from her saying she's outside his house, and that was during the short stretch of highway where she has 1 hour unaccounted for on her drive, when the rest of her drive she was able to accomplish within the estimated time that the mapping software would think that she would have. We also heard from Rob Adelson and heard that she told him not to talk to the FBI, and when he let her know that he already had, she said, well, you don't know anything anyway. She also had a complete lack of curiosity about what happened, according to him, and said that, I don't know and I don't care what happened, it's not my concern. We saw from the evidence that this defendant had an access to a large amount of cash, kept her cash in a safe, and that it was very common for she and Charlie Adelson to transfer cash back and forth to each other. We saw that she signed 44 checks to Catherine McBanois from Adelson Institute over the course of 2 years. This is despite the fact that Charlie Adelson had signing authority there. He could have done it himself if it was just him acting alone here. We also heard that in 2015, Harvey Adelson bought Adelson Institute back from Charlie Adelson, and we saw on the summary of the checks where roughly half the checks written to Catherine McBanois were written from fall of 2015 to spring of 2016, where Harvey Adelson would have been back as one of the primaries in the business. Donna Adelson, we also saw from the bump video, she was handed an article with Danny's picture about the murder, and she calls her son. He's the first call that she makes, and she tells Charlie specifically that this involves the both of us and that it involves the two of us when she's talking about the article that she was handed about Dan Markel's murder. So while there is a lot of circumstantial evidence and inferences in this case, there is also direct evidence, and the state argues that her admission that after being handed an article about the murder that it involves both of us and it involves the two of us to Charlie Adelson is direct evidence and an admission of guilt in this case. And she also tells Charlie Adelson the TV costs $5, or this TV is about $5. And that's the same TV that's referenced that Charlie Adelson bought instead of hiring a hitman, and that Wennndi's family, that her mother helped set up as part of her alibi and emailed Wennndy about that day after the appointment was made by her father. When the wire took place, she and Charlie Adelson are overheard discussing the fact that they don't need to be talking on the phone, they don't need to be talking in an apartment. They go to great lengths to take a walk outside, to sit down by the water where they can't be overheard, to sit by the pool where they believe they're not able to be heard by law enforcement. And on the wire, we see the same pattern of communication that was seen in the call detail records before the wire took place. Donna to Charlie to Catherine to Garcia. And this is consistent with McBanois' testimony of how communication was relayed in this case.
Before you continue, Mr. Bearden, specifically as to the argument of stacking inferences, what is the state's position?
The state's position is there are inferences in this case. There is circumstantial evidence in this case. However, there is also direct evidence. Even if there was only circumstantial evidence, the Bush case from the Florida Supreme Court did away with excluding every reasonable hypothesis of innocence in circumstantial evidence cases. However, we have more than just that here. We have this defendant writing checks to the middleman of this murder. We have her admitting it involves the two of us. And we also have her suborning perjury by admitting to one of her friends in custody, Patricia Bird, that she did do what she was accused of, That's what Miss Bird said on direct, and I clarified that with her on redirect. Was it that she told you that she just wrote checks, or did you specifically ask her, did you do what she's accused of, or did you do what they say you did? And she said that no. She said she did what she was accused of. And she's also offering to pay for false testimony from Bird and from Miss Bernhardt, and even writing a script for Miss Bernhardt to come in and recite in trial. We also have Donna Adelson adopting Charlie Adelson's extortion defense during and after Charlie's trial through text messages. And on the other hand, we have texts between Donna Adelson and Charlie Adelson in 2016 where we see that Charlie Adelson is telling her that his attorney is meeting with Garcia's attorney, and we see her reaction to that, which is not consistent with someone who believed that they were being extorted by Garcia or by that group for the past 2 years. We also see the 2016 text messages where we see Donna Adelson's reaction to Charlie Adelson workshopping this other possible theory of Dan Markel's murder. And our argument is that reaction is not consistent to with somebody who believed that she was being extorted, according to Charlie Adelson, for the past 2 years. We also have evidence of consciousness of guilt in this case. We have her fleeing with an emergency fast-track visa she sought to obtain within hours of Charlie Adelson's verdict. And within also hours of Charlie Adelson's verdict, sending a text that says, basically, you know I'm next, but that won't happen, and I'll take care of that. And then going to board this flight to a non-extradition country a week later. So the state's argument is all of that circumstantial evidence combined with the direct evidence in this case, in the light most favorable to the state, there has been competent substantial evidence that a reasonable trier of fact could find the existence of the elements of this crime beyond a reasonable doubt.
Well, the legal standard the court must apply at this point is reviewing the evidence in the light most favorable to the state. I believe in Turner versus State 29 Southern 3rd 361. In moving for a judgment of acquittal, a defendant admits the facts and evidence in every conclusion favorable to the state that may be reasonably inferred from the evidence. As to the direct evidence, the circumstantial evidence, and also the consciousness of guilt evidence taken together, I believe this is sufficient to overcome the matter that was raised in Williams versus State. The motion for judgment of acquittal will be denied at this time. Does the defense, as to counts 1 and 3 specifically of the indictment, does the defense have any other motions to raise?
Just one. Judge, there was an issue that you raised last week concerning advice of counsel. I don't know if we can approach to address that.
You may.
When I was still